Hello, my name is Ian Wu. I'm an attorney at Goyer, Rwano, and Thompson, and I work in the estate planning department. I work with a multitude of different clients, and a reoccurring question I always get is, what is the difference between a will and a trust? And do I need both? So today I thought I would take the time to explain what are the key differences between a will and a trust and how they might fit into a general estate plan. So the first key difference that I think we need to talk about is the probate process. So a will goes through the probate process, whereas a trust avoids the probate process. Now, the probate process is court oversight of distribution of assets and validation of a will. Probate can be costly, it can be time consuming, it can be also a bit expensive. But what I find a lot of people don't understand is that a will doesn't necessarily save you from avoiding probate, whereas a trust, it can be an agreement or a declaration, but it is a relationship, and it is a vessel in a sense that somebody funds with property to make a plan for themselves during their life and after they're gone, usually for their relatives, children, surviving spouse. And with a trust, unlike a will, the court steps back and allows what we call a successor trustee. That's somebody who the grantor or the person creating the trust and funding it elects to handle the distribution of assets after they're gone. Okay, so the probate process is probably the biggest key difference between a will and a trust. There are other key differences, though, that are very important. Another one is privacy. So since a will needs to go through probate, you need to lodge it with the court, meaning that it becomes public, right? So there's not a lot of privacy there. It becomes a public document. The court gets to review it. They obviously need to know who you are distributing assets to, right? Who you are electing as the person to handle the oversight of that will or the executor. Whereas a trust, right? You don't need to show anybody the trust. You just need to show proof that the trust exists and that a certain person has authority to act on behalf of the trust. Now, this is usually contained in a separate document that's drafted alongside a trust called a certification of trust. That is usually what's given to banks so that they can lodge who exactly has the authority to act on behalf of the person or the trust that owns the account, okay? A third main key difference between wills and trusts is going to be control. So a will usually only takes effect, or it does take effect, after the person's death. It doesn't manage any assets while the person is living. Whereas a living trust, for example, that is effective throughout the lifetime of the person who funds the trust, the settlor or grantor. They can amend the trust, they can withdraw assets, put assets in. Think of it as, the best analogy I have is a suitcase. So think of the trust as a suitcase where throughout your lifetime you are carrying it with you and you've got a special set of instructions on it. Throughout your lifetime, you can open up the suitcase, you can put items in, take items out, withdraw money from the suitcase to spend it, right? And then when you pass away, the person named on that instructions on the suitcase, they take charge of that suitcase and they go, okay, the person who owned the suitcase wanted me to do X, Y, and Z with it, and they would then distribute the assets according to those instructions, right? And the court sees that and they take a step back and they say, okay, this doesn't need to be probated, right? But throughout that person's lifetime, they have full control over that suitcase. Whereas a will, I akin that more to maybe a set of instructions on your own body, right? And think of all the things in your pockets and that you're carrying, that all needs to be probated. And only when you die, then they look at those instructions and go, okay, we need to lodge this will with the court and we need to figure out, and oversee how all of these assets on your person are going to be distributed. So that's the main difference with control with a will and a trust. Another very important aspect of what makes a trust and will different is the guardianship of minors. So a lot of my clients come to me and they have children. And a trust doesn't necessarily elect who the guardians are if the parents are no longer in the picture or are deceased. The will, however, you can name guardians to do that. So that's something else. It's another reason why, a lot of parents, they come to me and they say, do we need a will or a trust? Well, one, you're going to want to avoid probate, and two, you're going to want to elect guardians. So really, you're going to need both. Is generally what my advice is for them. In this doesn't apply to everybody, but what we normally do is we draft up a trust and then a will at the same time. The will we use to elect the guardians of the trust, and the trust we use to determine what property goes where, at what age do kids get a certain amount of money, right? All of those distributions, that's planned for in the trust. The will we use for the election of guardians, and we use for what we call a pour-over provision. So it is a safety net to avoid a full lengthy probate. We include in the will a provision that says, if I pass away and I have an asset that wasn't put into the trust, then the will would provide that I therefore gift it to the trust. And that's what we call a pour-over provision in a will. And it essentially serves as a safety net to the trust to make sure that if something was inadvertently left out of the trust, it can be moved in by merely going to the court and showing them that it was the intention of the decedent to have this placed into the trust. So whether you need a will or a trust, it's going to depend on your certain circumstances. They're very different things. They've served different purposes. They both do somewhat determine how property is distributed, but they function very differently. And there are a lot of key differences when making an estate plan as to whether you need a will or a trust. Normally, it's both. But in any event, it's important that you consult with a person who is experienced in estate planning and that pays very close attention to not only the drafting of your estate plan, but your individual circumstances and your desires and what you want to do with your property, so that they can effectuate a proper estate plan for you to, one, make sure that your loved ones are taken care of, and to make sure that your assets are protected from either probate or from going to somewhere you never intended them to go to, from reassessment, or from other disputes that may be thrown in the way to challenge what has been what your plan is. So, if you or a loved one are looking to draft an estate plan, my name is Ian Wu, and I'm here at Goyer, Rwano & Thompson for your needs. Go to our website if you want more information at www.grtlaw.com. And thanks for listening.